So, sir, with that, I'll hand it over to you. And I'm very excited to have you. Thank you so much for joining us today, sir.
Thank you very much, Professor Davis. It is obviously my pleasure. It's always my pleasure to appear in a room with military personnel, uniformed and civilian. And thank you for that long introduction, and I apologize to the audience for that. I will say that the Marine Corps infantry officer part does remind me that the best legal training I ever had was serving as a Marine Corps infantry officer. Not law school, of course, and that was because I got yelled at a lot, always good practice for a lawyer, and I had the opportunity to make a lot of decisions, or not, for which I was held accountable. And that's great legal training, because you can be a great lawyer, but if you're not willing to actually make a decision and cut one way or the other, or provide essential nuance, then you're not going to help the United States, U.S. security and law. So thank you. Here's our topic for today, promise and peril, and the title comes from the new executive order, or relatively new executive order, on artificial intelligence from October 30th of 2023. And it captures with alliteration the essence of AI, right? The essence of AI, which is it comes with great promise and with potential peril. And as lawyers and practitioners, we have an important role to make sure we get more of the promise and less of the peril, or hopefully none of the peril. So here's the outline. Oops, maybe not. Here's my outline for today, brought to us by President Zelensky, reminding us that there's more than one national security challenge at a time, and Ukraine is on the front line of freedom. But here's the outline. If we did all this, lucky you would be here for 7 days and 14 hours. But what I'm going to do is a quick level set through part one and part two and part one and part two, just making sure we're all on the same page. What is AI, that sort of thing, the kind of thing I would cover if we were doing a sort of AI 101 start point. But since I'm in a room full of military officers, and I'm in a room full of Air Force officers, I don't need to do that basic stuff, because I know you're already there and beyond. So we'll go through that fairly quickly, if you don't mind. And then if you do have questions about it, we can double back on the Q&A. I've been given a target time of 30 minutes. And as you will know, those who've seen me before, that means I'll come in somewhere between 4 hours over or 30 minutes short, but let's see how we get there. So part one, level set. We talk about emerging technologies. They're no longer emerging, right? They're daily technologies, DT, or everyday technologies. And that's certainly true for artificial intelligence. The two that are also of vital national security importance, there's many important national security technologies, some emerging, some not. But the three that I have my eye on are artificial intelligence, synthetic biology, and genetic engineering, which can lead to great harm, as well as cures for disease and other things like that. And then quantum information systems. We primarily focus and talk about quantum computing, but the Chinese have spent a lot of time working on quantum communication as well. So we need to keep our eye on that. And of course, whoever gets to quantum computing first will have a huge first mover advantage and a breakout moment, equivalent to, I think, well beyond the equivalent to a Sputnik moment. And there, of course, is President Biden looking at a quantum computer. If he understands what's going on, he's a smarter man than I am there. But the important thing is that a president of the United States is looking at the quantum computing model there. That tells you something about its priority. But our focus today is artificial intelligence, which is an enabler of all the technologies. And and the essential ingredient to so much of what we're working on. So here I go on that. Here's AI in one slide. This is just a level set. There's the definition I like from the National Security Commission on Artificial Intelligence. First of all, it's not written in technological Greek, and it's just a couple of sentences, right? And it captures some of the essential points, which is AI is not one thing. It's not a single piece of hardware or software, but a constellation of technologies. Different things are enabling the AI revolution. And it also means it's harder to regulate AI because we're not really all thinking that we're regulating the exact same thing. We may be talking about very different things, but it's a constellation of technologies, which means there's a lot of moving parts. On the left, you see one of those moving parts, which is the development of neural networks. Today, a lot of the impetus for sort of the public interest in AI comes from the onset of generative AI. We've had forms of generative AI all along, but with ChatGPT-3, then ChatGPT-4, it's become sort of a mainstream capacity. And there is a simple definition. There are more elaborate definitions of generative AI, but essentially it's AI that generates stuff, synthetic content. And what we mean by synthetic content is artificial content, right? Deep fakes are synthetic content. Synthetic content doesn't have to be bad, but it could be funny videos and stuff like that. But that's what's sort of driving the debate right now. I'm incapable of doing anything in one slide, so I lied. That was not AI on one slide. It's AI on two slides. And here are some of the strengths and weaknesses of AI. You know this already. You know it as users. You also know it as practitioners, and you also know it as students of the field. And we're all students. If anybody says they're a master of AI, they don't know what they're talking about. One of the things that's interesting about this field and challenging is literally every time I've made a presentation on AI, and that's quite often since I was first tricked into studying it in 2017, every time it's a different presentation. Sure, my definition of AI can remain the same, but I am always having to change things, identify a new strength, identify a new weakness. And as you'll see when we get to the meat and potatoes of this presentation, there's three things I want to focus on today, which are sort of relatively new. In 6 months from now, you'll be, oh, tell us something else. That's old news. But it's good to keep our eye on what are the strengths and weaknesses. Just for the sake of this slide, we'll say obviously one of the strengths is the ability of AI to aggregate data, structure data, and derive meaning from it, right? And do so instantaneously. And then one of the weaknesses that has been focused on with the ChatGPT family and other generative AI platforms is the tendency of AI to hallucinate. And lawyers have gotten caught up in that because one thing AI likes to do is hallucinate about fake cases and answer your legal questions with made up stuff that can be very convincing. More on that in a second. So I think AI presents sort of three buckets. I try to structure things. I'm not here because I'm an expert in coding. I'm not here because I'm an expert in the technology of AI. You might say I'm just here because you're courteous enough to invite me, but if I have something I'm bringing to the table, it's a desire and ability to try and structure the material so that mere mortals like lawyers can try and regulate it, assess it, use it wisely and well. So I see three buckets of issues. One is what I call the centaur's dilemma. This comes from the DoD model of AI, which is part machine, part human. That's the centaur, not a human and horse, but a human and machine. And the centaur's dilemma is in every context, we have to decide what part to be human control and what part to allow the machine to act autonomously. And the more human control you assert, the less benefit you get from the machine's capacity to do things instantaneously, right? If you're doing cyber defense or attack, you can't stop, have a principals meeting and decide what to do. Too late. The machine has to respond instantaneously to the attack if it's going to be effective. So you have to figure out in advance how to assert human control by how you code and how you do different things. So in each context, the human machine teaming is going to be different. And that means lawyers have a lot of work to do to assess each of those contexts. So bucket issue number one is sort of the human machine interface. When do you have the machine act autonomously? When do you do augmentation of human capacity? And when do you say this is, in essence, an entirely human question or problem to solve? The next bucket is bias. Lawyers talk about bias in a legal sense, and usually sort of equal protection, suspect classes, bias, racial bias, gender bias, age bias, and so on. And an AI which is designed, programmed, used by humans, brings together all the human biases because it's trained on human data as well. ChatGPT is trained on internet scrapings. So you're getting all the noise that comes from the internet and social media. But one of the important things is to know that with AI, there's a lot of other bias that comes in to influence the accuracy of outcomes. And lawyers need to understand those types of bias as well. Technical people do. We have to do so as well. So one of the things I've tried to do with my writing and with my colleague Lori Hobart is to explain in plain language to normal people like me what type of bias these things are. If you're pulling out a whiteboard and putting math equations on the board to explain to me what bias is, I'm not going to be able to figure out how to deal with that. I need someone to explain it in plain language, and then I can go look for it and see. So that's our next bucket of issues. And then the third, of course, is data. Data is the fuel. A lot of things are the fuel of AI, but data is one of them, and massive amounts of data, right? And when we talk about generative AI and foundational models in a moment, we're talking about foundational models that are over 10 billions of parameters. So they're searching for 10 billions of different parameters and what they're looking for. And you don't do that with 5 documents. You do that with the internet, the scrapings of the internet. And then we have, as we all know, we have questions about who owns it, where's it from, is it good data, bad data, all those sorts of things. Again, our job here is just to set the table, not to pretend we've gone in deeply on each of these issues, but rather to spot them so we can get to the new part of what's new in this field, which we'd like to talk about. So here are some of the national security risks and uses from a policy or commander's perspective. I'm not going to do a dramatic reading of this slide. You can review it later, but obviously we have all the traditional uses. We tend to focus, and I know the commentary likes to focus on things like laws, lethal autonomous weapon systems, but of course AI is already embedded in our logistical capabilities, our medical capabilities, and so on. And then on the other side are some of the risks, national security use risks that come from the AI. Again, that's a topic for another day. I write about it at some length in the Centaur's Dilemma and in other places. And I'm trying to get to where I wish to go. And then the next 10 years, this is a menu. This is not a report, but I'm constantly thinking, as you should be constantly thinking. And frankly, I'm more interested in what you're thinking than I'm thinking. Where's this all headed? Where's this all headed? And in the Air Force, one place it's already headed is going from pilot to at scale on things like the virtual training of pilots. So we've seen that in just the past year. 5 years, go from sort of a pilot project to say, can you do virtual reality training for pilots? And then can you do it in a movie called Mission Impossible? And now full up contracts for millions of dollars to train Air Force pilots using VR. So these are some of the other things that will be happening. It's an iterative list. One of the things that is very important to know for lawyers is there's a lot of work being done on AI verification. And those AI verification, just like you can't have arms control without the ability to verify compliance, it's very hard to regulate AI if you have no tools to figure out what the AI is doing and whether it's been accurate and so on. And you should know that those tools are here and they're coming. And we need to keep our eye on them. More on that in a second. And then there's this bit, which is the old debate over whether this will be our last invention, which is James Barat's book over there, Our Final Invention, which is the school of thought that says AI will eventually consume us. And then there's the middle ground, which is represented by Stephen Hawking, which is this could be the greatest invention ever for humankind or the worst. It could go either way. And then there are optimists and people who are everyday users who think we can do this wisely and well, represented by the chief information officer for the JAIC. I don't worry about this. I worry about this only in the sense that it shapes popular perceptions of AI. And if I'm a lawyer and I'm talking to a jury, for example, I need to realize that when they're thinking about AI, they're not thinking about data sets. They're probably thinking about a movie depiction of AI. So I need to know that. But my basic line about this is I'm not worried about existential risk from AI because there's so many ways we're going to do ourselves in first, well before we get to super intelligence. Okay, there's a national security imperative and legal imperative to know this stuff and apply it, right? We want to maximize the benefits, mitigate the risks. That's the wonderful Jason Matheny, who's now the president of RAND Corporation, RAND, which has done so much research for the Air Force over the years. And that's a great title for him, like Apocalyptus, right? It combines living in the world of synthetic biology and fear, but also in the world of optimism about how we can shape these instruments for good and for positive good, which is a lawyer's job. And then, of course, ethical use of AI is going to distinguish the United States, we hope, from authoritarian uses of AI in Russia and China, for example. And what I always like to explain to people, and this is essential to know as a national security lawyer, is you articulate what the law is, but you also want to explain why the law leads to better security outcomes. And here, the application of law and ethics to AI leads to better accuracy in the AI. If you address those three buckets, the centaur's dilemma, bias, and data, you're going to get a better, more accurate result. That's good for national security. So the policymaker should want the lawyer in the room making the tool more effective, not just more lawful. So here we get to the 5 phases of AI regulation. This is me just trying to create a structure around what to talk about. We have the realization moment. We're past the realization moment, but we need the realization moment with synthetic biology. Then you get ethics and principles. Everybody has their principles now. We want to move beyond principles and to start applying them. Then from principles, you get principles into practice, legislation, and then international adoption and integration. Of course, you can do all these things at once, and we're going to scoot ahead. And happily, we're sort of in the phase now, which we weren't 6 months ago, where we're really in stage 4 now in the national security field, legislation and directive, not principles. This is good news. Now we got to figure out how to implement all that stuff. What happens when you don't have a regulatory regime? You use the law you have, The constitutional law becomes more important because you always have that law. You always have the Fifth, Fourth, First Amendment. Litigation ends up deciding a lot of tough issues because the parties aren't waiting around for the government to do something. You apply law by analogy. And one of the areas where I derive a lot of metaphor is the law of armed conflict. And the principles of the law of armed conflict that can be applied to AI applications. Okay. So now we get to part three in the meat and potatoes. And so there are three elements to this. First, I want to tell you what I think you should know about the AIEO from October 30th. Then I want to tell you about what I think you need to know about the EU AI Act. And then I want to speak a little bit about the development of ethics and lawyering, and then bring it all together with a homework assignment. You'll be very pleased to know you'll be getting homework at the end of this session. The AIEO, what should a national security generalist know? First, I think it's an achievement. It's a very long executive order. There's a sort of kitchen sink aspect to it, but it's a real thing. Unlike some executive orders which say it's the policy of the United States to save the world, which really doesn't tell you what to do or how to do it. This executive order has concrete actions in it. In fact, so many concrete actions, there are over 90 follow-on actions, or approximately 90. I counted 87, and then the next time I counted 88. So I said, okay, I'm going to call it approximately 90. But they're follow-on actions. X and Y has to be done in 270 days. A and B needs to be done in 90 days. So one of the things it does is it establishes lead agencies. If you're old like me, you've been through this. One of the things the government likes to do is fight over who's in control. Well, first of all, with AI, the joke's on us. Google, Meta, and others are in control, not us yet. But you always want to know who the lead agency is. And interestingly, the lead agency in this executive order, not the only agency, but the lead agency is essentially Commerce Department. Interesting and very good. Our commerce, of course, comes with NIST. And so we've resolved that debate. Good. And then there are very specific concrete actions rather than general palliatives. So the thing starts with a bunch of principles. And I'm like, don't do the principles thing again. Let's take action. So I'm going to start talking about some of the key actions. This is a menu. It's obviously not the exhaustive menu. But this is some of the national security components of the EO that I think you should be aware of. You can just go to the sections and read more. Ensuring safe and reliable AI. Okay, what's that? Well, one of the things that is here's a concrete step. It directs the Secretary of Commerce to use the authority of the Defense Production Act, Section 705, to gather information from companies about anyone who is using large data modeling, using their computer systems, their cloud systems, their AI systems to do large language modeling that could be used for nefarious purposes. That's huge, right? That's a know your customer kind of thing. And letting the government know who might be up to no good, like creating biological agents using large data runs. Same thing with 4.3, which is doing the same thing with cyber and critical infrastructure. There's the Department of Commerce issued just 3 weeks ago, January 29th, whatever that is, a notice for comment in the Federal Register about a requirement to report to the government anytime a client is a foreign person who's trying to access a modeling run or a system that could lead to malware or cyber threats. I love Section 4.5. It's very specific about telling the government to figure out methodologies for dealing with synthetic material, your deep fakes, among other things, how to create mechanisms to authenticate them, things like watermarking and other detection methods. Stay tuned to that. I'm going to keep following that one. And that's a 240 days task. 240 days. Who came up with 240 days? But I have booked in my calendar 240 days from October 30th to see if something materializes. This is one you should be tracking. 4.8. So you're going to, don't roll the drums yet. It says 4.8 directs the National Security Advisor to write a memo. Wow, that's exciting. But the memo is a memo outlining about uses and limitations on the national security uses of AI in the government, by the government, for military intelligence and national security purposes. If I'm you, if I'm the General Counsel of the Air Force, if I'm the TJAG of the Air Force, et cetera, I want to be in the room, the figurative room, metaphorical room, where that memo is being written. I need to shape it with my knowledge and my views. So that's July 26th for people who are following. Don't show up on July 26th and get fussy about not having how the memo turned out. So, and then I got to speed the tape up here. 10.1 creates chief AI officers, requires each agency to have a chief AI officer. That's like having Space Force. If you don't have someone whose job it is to come to work every day and think about AI and get the agency to think about AI, it's not going to happen. Just like you can say the Air Force is in charge of space, but if you come to work every day and you're thinking about pilots, JAGs, and space, every day is not a space day. Now we have people who every day is an AI day, and that's what we want. Okay, the EU Act. I know you're all excited to learn about EU law and process. My joke, which is not really a joke at all, is I have a better ability, I'm more likely to understand what dark matter and dark energy in space are than I am how you legislate in the EU. It is the most complicated thing I've ever seen. But they are very close to actually passing their AI Act. They are the first mover with legislation. Now, the president's executive order was kind of an effort to jump the queue, but the AI Act in Europe is the first mover in terms of legislation. So what do you need to know about it? It addresses generative and general purpose AI. Generative AI, we know general purpose AI is artificial general intelligence. That's AI that can move from task to task freely, train itself, and so on. And it applies to providers, developers, et cetera. It does not apply to military defense and national security systems. They're out of it completely. So that's huge. And then it has very narrow, it has rules about law enforcement and biometric. It's a lot of focus on real-time biometric data. Why do I want you to know these things? I want you to know these things for a couple of reasons. First, one, US companies that want to have access to the European market are going to have to deal with these. They may end up then compelling US companies to do things in the US market in order to meet the EU market. They're also potential models for us. Why not learn from what the Europeans are doing, see what works, see what doesn't work? And so I take their menu, I look at what they're doing, I look at their tasks, and I say, what from that can I learn to apply to national security applications and US applications? So they have 4 categories of AI. So that's one, an effort to get around it, to create rubrics that allow you to understand it and work on specific tasks, not general tasks. So the category 1 is AI with unacceptable risks. You're not allowed to do those things. You can have a debate over whether you can tell companies not to do subliminal techniques. That's what advertising is about. So they're basically saying no more advertising, but that's a sidebar. But no social scoring, for example, in the Chinese model. Okay, that's not permitted. High-risk systems is where all the action is for us. Their high-risk systems are one that address health, safety, fundamental rights, and so on. Now, you can debate whether those should or shouldn't be the high-risk areas. that's good for us to figure out, saying, oh, that's interesting. They use fundamental rights as a high-risk area. Should we do the same? Or is that too amorphous? And then if it's high risk, this is a menu, not even the complete list. If it's a high risk AI or a general purpose AI, artificial general intelligence, then you have to do all these things. And they've created an authority to regulate it, an AI office. So more bureaucracy. But these are all the different things that might be required if you have a high risk AI application. Automatic logging of what the AI does and doesn't do. Human oversight, look at that, human oversight, including a stop button. That will be interesting to see what that looks like and how it works and whether it works. There has to be an authorized representative who can explain to the government what the AI is and does from the company that developed it and is using it. Think about Crawford and the debate over who's going to come in and testify about what the AI does or doesn't do, and who's the person who can do that. They've cut to the chase there and said, you got to designate that person in advance. So again, if I had the 7 hours that I had been promised by Professor Davis, I would go through each of these and articulate for you what they are. But what I really want you to do is to look at them and say, which of these should we apply to my Air Force medical AI system, to my DoD target queuing system, if any of them? Okay, third bucket of new things, and not so new, right? Lawyers have been using AI-driven things for a long time. Westlaw, Lexis, right? If you use Westlaw, Nexus, or spell check, you've been using some form of AI, at least arguably, for years. I believe national security practitioners should use all the tools available to them, but they should do so wisely and well. And you can make a lot of mistakes with AI, and we've had many cases where, not many, but we certainly have notorious cases of lawyers using chat bots to write memos and briefs, and they submit fake cases, and we all say that's ridiculous. Remember the 3 buckets, and the question lawyers should be asking is not should I or shouldn't I use AI? You should. You should use all the tools available. How should I use them? What's AI better at? What am I better at as a human? And what am I best at when augmented by human capacity? So discovery is an obvious one, but there are a lot of other ones. I can see AI applications being used to evaluate judges and predict, digest every opinion I've ever written, and then predict what I will write in the next opinion by each topic in each case and each issue. That's something I anticipate AI will soon be doing. So ethics issues and rules for lawyers, competence and diligence, right? You don't submit a brief to a court that you haven't read and verified and read all the citations. That's nuts, right? So the problem is not that someone used ChatGPT to research something. The problem is they didn't check the research and read the thing. That's nuts. Who does that? Client confidentiality. These are from, the first one is all me, but the next 3 are from a terrific Florida bar opinion that just came out in January, and saying, look, watch out for client confidentiality, for example, because if you're using a chat bot, the chat bot is training on your data, right? And it's absorbing your data and incorporating it in the next thing. You may find your client's information as part of an answer in the next use of ChatGPT from somebody else. That would either be a waiver of confidentiality or it might be a disclosure of confidential information. Be careful. So the point is here, what's new here? We're starting to have a framework for using AI in the practice of law. No more excuses about, I didn't know what would happen. I didn't know it would hallucinate. We're on fair notice as practitioners of what the ethics issues are and how to use this stuff. That's George Boole, who created the Boolean system of logic that was used by lawyers for years to search data. So this is not new stuff. What is new is the Chief Justice of the United States using his end-of-year report in 2023 to discuss AI. That's interesting. Okay, we'll skip this in the interest of time. I want to give you your homework. So this was, what are the issues that I think these EO and the EU Act and the EO have left on the table? But here's your homework. What can lawyers do, should do, must do? Get in the EO room. So that EO has all those follow-on actions. And some of the follow-on actions, so some of the actions are like write a memo. Well, someone's going to write a memo, then somebody has to implement the memo. So make sure you're in the room where the action happens. Identify key forks in the road, key decision points, like when something is designed to do something that's never been done before, make sure you're there. That's a fork. It's a fork again when you decide to develop the thing. It's a fork again when you decide to deploy it. There are a lot of forks in the road ahead. Make sure you're there guiding people. Don't wait at the end and do your lawyering and analysis then. Law, ethics, and policy. Translate and articulate. That's what lawyers do. When there's a new AI system that's coming out, don't wait for the press to inquire. Don't wait for the crisis about how you use the thing or whether it's a killer robot. Too late to control the narrative and explain what it is and why you're doing it. Explain it on the front end. And lawyers are very good at that. And you see my friend Spot over there. That was the police robot that in New York City that they used one time, and they hadn't articulated what they used it for. So everybody said, it's a killer dog, it's going to shoot people. And of course it wasn't. It was just a traditional robot that police forces have always used to look around the corner of buildings to see if someone was about to shoot them. Military uses robots all the time, but they didn't articulate what it was. So Spot had to go off for a while, and then he came back. And where did he come back? He came back with the New York City Fire Department. That's Spot. Notice that Spot has changed his colors. He's no longer police blue, he's fire department yellow. The problem there was not with the technology. The problem was with failing to explain the technology, its use, and its ethical boundaries. All of these things. I'll go ahead and skip this quickly. So you have to, for each application, cover those 3 buckets and then deal with the legal policy issues. I remember the cyber debates in the 1990s and the 2000s. They were the same debates. Who's going to be the lead agency? When is a cyber attack an act of war? Okay, these were obvious questions, but we didn't resolve them. To resolve the debates, don't sit around and say, gosh, it's really hard to decide with the First Amendment when you can use an AI application to search for domestic extremism on the internet. I agree, that's a very hard issue. Apply some guidelines and start doing it. And if it takes case-by-case analysis, go for it. But don't sit around and talk about how hard it is. Make the decision and pivot off what you've done. Decide how you're going to use the DPA. All these things. These are known questions. Answer them. Okay, I'm almost done. Don't worry if you're still hanging in there. We have to do all the backroom stuff. How we practice law has to change. We have to be the person in the room. Contracting and personnel is critical. Move upstream. We can't sit there and wait for the policymaker to come to us and say, hey, we got this application, how should we use it? You should have been there in the design phase, figuring out how it's going to be used and implanting into the code key legal principles and guidance. Okay. See, now I am. Final thoughts. The final thoughts are this. One, final thought. Lawyers are on the front line in national security. We've always been on the front line in terms of protecting and preserving our values, even as we protect and preserve our physical security. But with emerging technology, as much as any other space, we are on the front line in terms of defining whether it's going to be designed and used wisely and well and ethically or not. And we can only do that job, that critical job, if we're in the room where the action happens. So I'm trying to give you some of the equipment and knowledge that will allow you to do that, but I'm living proof. I am living proof that a normal person who could not even spell AI when I started looking at this stuff can get in the room and provide meaningful input. So please do so. That concludes my presentation. And I would be happy to take questions. Complaints should be referred to Professor Davis. Questions can be referred to me. Thank you.
Well, thank you so much, sir. It was an absolutely wonderful presentation, and as you might imagine, we've got the questions are rolling in. If folks want to add Q&A in the Q&A box or in the chat, either one, I can see both. So we'll start with a question from Mark Meyer. He is joining us and had a question about jurisdictional boundaries. So if I'm understanding, Mark, your question correctly here, how do we balance human control AI systems across kind of the spectrum of cases that we're going to see internationally and domestically? If I'm capturing that right, Mark.
So the word jurisdiction, I think, is used here as boundaries and not court jurisdiction, I presume. So I don't have a clever one-part answer. I have a basic answer, which is one application at a time. And the mistake, maybe not mistake, but the EU Act is trying to not put one shoe on every foot, but it's trying to mush a lot of stuff into one area. And because it's very hard to legislate one application at a time. But the problem is every application is different. Every application will be trained on different data. Every application is, not every, but most applications are iterative, so they're always changing. So the only way you can define the correct boundary is one application at a time, over and over again. Because once you think you've got the boundary right, the AI grows, it learns, it iterates into a new version of itself, and you may find that the boundary is incorrect. I thought I programmed it to only counterattack in cyberspace when this, and this happened, but it trained itself to preemptively strike because it said this is a better way to defend yourself. And it may well be a better way to defend yourself, but it may cross a boundary that you had not anticipated would be crossed. So I'm sorry, we need more lawyers, not fewer. But we need to work time and one step at a time. I hope that's responsive. It doesn't answer the question, it responds to the question.
Yeah, yes, sir. And it's one of those, I think, such an evolving area that that's going to take kind of the whole of all of us putting our heads together on this. So thank you for those insights, sir.
By the way, in some of it, like it's really hard if I say, go do all DoD AI and figure it out. You're going to be like, oh, I think I'd rather go, play tennis. But if I say, oh, here's this application for deciding whether someone should get parole or bail, you can look at that and a lawyer will look at that and say, are you kidding me? They're using this for that? Do you know what this has been trained on? It doesn't take a lot of analysis to say this seems like an inapt application, or it's a wise application, but it needs human control. So it's not as hard as it sounds in the abstract if you go about doing it in the real world with a specific application.
Well, and that's a good point, sir. Just to kind of tag on to that, I know many in our audience are familiar with the Williams case. I know my students certainly are. The Clearview AI and the use of facial recognition technology in Detroit ended up being an issue of note, we might call it, with regard to kind of the data. And in the complaint, I actually had my students read the actual original complaint that was talking about the data, of course, that was trained on, which was actually a really apparent one, but the NIST, speaking to your comment on the Department of Commerce, has done several studies on the effectiveness of the actual algorithms themselves in being able to sort and do justice to the data as it's going through the actual, neural network, whatever one that the neural network is they're using. So I'd be interested in your thoughts on, what kind of level of diligence do we as attorneys and practitioners need to be employing? Obviously we're not going to be AI experts, but do we need to have a Rolodex of, to use the old term, do we need to have a Rolodex of sort of experts that can help inform our opinions so that we don't end up accidentally training an AI, generative AI, to go ahead and disclose client confidentialities or anything like that?
So the question is, just how competent do we have to be? Or what does reasonable mean in the context of the ethics rules, right? Just like the DoD regulation on autonomous systems talks about appropriate human control. Well, that doesn't, that's the whole job, is figuring out what is appropriate. So you need to know the terminology, so you know what everybody else is talking about. You do not need to know coding. Is it helpful to know coding in some contexts? But the Jason Matheny's of the world who know coding, they're not going to tell you need to be a coder. And in fact, when you're not a coder, it may help you not assume certain things. I'm trying to figure out how to capture the essence of competence with AI in less than 7 hours. First of all, every lawyer has to be competent with AI. So one thing I've seen in government agencies is a model that says, oh, that's Baker's job. He's the AI guy. And I do contracting. And I'm like, no, we're all AI generalists, because you should be using AI in contract review, for starters. Secondly, a lot of the contracts are about AI and AI talent. So we all have to be practitioners of AI on some level. And I would say teach it. I assume it's taught at the Air Force Academy, but it ought to be taught not just as a technology class, probably in the computer science program. It should be taught as a law class or a law and policy class, 2 of the 3 triads of the stool: law, policy, and technology. I don't know if that's responsive. I really want to emphasize, if I can do it, you can do it too. I'm not saying that to you. I'm saying it to anybody in the audience who says, I can't even turn my phone on. How am I going to become an AI lawyer? And the answer is the same old way you've always become a good lawyer: through study, reflection, and remember what you bring to the problem. You bring judgment, common sense, and the ability to say, why are we doing that? And how is that consistent with the Fourth Amendment? And that's what we do all the time.
Well, thank you for that insight, sir. I really appreciate that. I have another question from Mr. Steve Wood, and I think this is kind of a hybrid question, and so I'll add kind of the second part first. He's referencing kind of the value in your mind of DoD funded collaborations globally or even domestically, and of course you've got examples of different types of tech transfer agreements, CRADA, and things like that. But you're kind of from that larger policy perspective that you bring. What are your thoughts on those types of global collaborations?
Good. I like that inquiry and thinking. One of the things that makes AI interesting to me as a student of government is, unlike, say, the space program in the 50s, 60s, 70s, where it was driven by the government. The government was not only the critical actor, it was the monopoly actor. And so companies were responding to the government. AI is not driven by government actors, by government contracts. There are certain companies that live and thrive off of government contracts, but we all know, if we just open our eyes and read the paper, that AI is being driven by industry, as they say. And so the government has to be comfortable, which it's not, has to become comfortable doing things like talking to industry about classified things, talking to industry about what we do and why we do it. And so too academia. A lot of the work in academia, a lot of the foundational work, edge work, is being done at places like MIT and Caltech. And if you're sitting in the Pentagon and you don't get out there to Silicon Valley or the metaphorical Silicon Valley, wherever it is, you won't know what's going on. And we will deprive the nation of essential tools and so on. Likewise, we all know this. One of the other things that's happening is the CHIPS Act, and the focus on chips now is actually kicking in. And we know that up here in New York because just this week, there was a $1.5 billion contract created for a company outside of Albany. And we already have one, Micron, in the local area to make chips as well. Big bucks. We're still far behind on where we need to be. But when I was at the NSC, I never came to work thinking, oh, today is the day I need to go talk to industry, right? It's like, talk to anybody. Don't do that. I'm in a skiff and I'm staying here. And we will lose the technology race with China if we stay in our cones. Our advantage over China, they have the advantage of authoritarian control focal points, right? If they say everybody's now going to work on missiles, everybody now works on missiles. So they have certain advantages. We have the advantage of talent. Nobody's saying, oh, I'm going to resign my position here at the university and go over to China and work for them, right? They want to come here. So if we're going to have the talent, which is one of the things that AIEO does, is mechanisms to attract and hold talent, we're going to have to work together. If people are going to come to government with AI talent, we need to encourage them to come to government. And that takes a comfort level across cultures that the USG has never had. Comfort level with academia, comfort level with industry. And so here's the foreign part as well. Where's a lot of the action happening? CSET, which is the group I was part of for a while at Georgetown, the Center for Security and Emerging Technology, does a great job of mapping who's deleted. It's so easy to say, oh my God, China is head in quantum computing, or, oh, we're the masters of AI. CSET breaks it down and said, no, it's not that easy. This country is ahead in this kind of chip that is necessary for this kind of large language modeling. This country is ahead in this kind of computer technology that's good for modeling BLUP. And it turns out it's not just a US-China thing. And so if we are going to, I don't want to say prevail, if we're going to make sure that AI is used wisely and well for good, rather than merely as an instrument of power, we need to partner with the nations that are edge nations in the area. Singapore, the Netherlands makes a lot of has a chip capacity. Who knew, right? And so international interoperability on the industry area, not just on the NATO area, is so important here. Disinformation. How are we going to combat disinformation if we're not working with our NATO allies, who are, if you go to Estonia, go to the Baltics, and you'll get a class in responding to Russian disinformation. We need their expertise. We can't get their expertise if we're sitting in our skiffs saying, I can't talk to foreign governments.
Yes,
I hope
sir.
I'm responsive to that good question. I'm happy to follow on whoever that was. If they want to go save the world, I'm all in favor of it.
Yes, sir. That was Steve Wood, and he had a follow-up question. We may have time for it. We've got a couple of other ones that are talking about sort of maybe some of the practical thoughts that you may have on introduction of evidence at trial, especially kind of this debate with whether or not the judge needs to maintain that sort of, and I think the judge will maintain that gatekeeper action, especially in deep fakes. But would be interested in your thoughts on how much of an expert needs to be involved. And I know that's part of the committee's review this last fall of the federal rules of evidence. And it looks like you might be going and get that book, sir.
So in response to that question, I've quickly written this, which is an introduction to artificial intelligence for federal judges. So if you're worried that if you're on this call and you're worried, oh, I'm late to the party, lawyers tend to be a little late to the party, right? The technologist is going to get there first. In the policy person and then the lawyer. Well, guess who's later than that? Judges. Judges are always the last to get the memo. And part of that is the process of, appellate courts are going to get, breaking news. They get 5 years after the fact because the appeal comes in 5 years later. But I addressed that question in this. This is available online. It's free. It's published by the Federal Judicial Center, and it is the best book ever written on AI for judges. It's also the worst because it's the only right now. So no credit to us. It's the worst book ever written on the topic. But it addresses the question of the role of judges in authenticating AI. When should they get involved in it? And of course, AI is a 403 nightmare. If depending on whether you're the proponent or the opponent of a proffer of AI generated information, first of all, relevance is easy because AI is always about predicting. And if it's more likely to help you figure out if a fact is real or not, AI is like it sort of defines the term relevance because of its predictive capacity. However, it has a lot of 403 tail to it. And judges are going to have to figure out how material is that evidence that I should go through the process of validating it through the 403 process before I let that evidence come in. It's a great line of questions. I'm glad that judges, I've had the opportunity to brief a number of courts on AI, so it is fully embedded now. They've moved past that stage of the recognition stage, right? And they're going to the implementation stage. And in the courts, you don't have legislation, right? You don't have a directive, but what you might have is a court rule or an understanding how court rules apply. One last point here. Case law is going to be a nightmare with AI because the AI, even if you say, this case is about whether this one application of AI, this facial recognition algorithm, can be admitted in court to demonstrate that it's more likely than not that Baker was the bank robber. The next court can't rely on that because the algorithm has already evolved and changed, and we hope for the better, but not always. So the next judge can't just say, case law, you can admit that or you can't. The next judge has to do the exact same thing and say, is this admissible now? And so I suspect we'll end up with some sort of a, I'm embarrassed to say, I can't even remember the Dober type factors case somewhere along the lines with AI. But again, I'm a very contextual person with AI. It's got to be one AI at a time. It can't just be henceforth all AI is admissible in court or it isn't. That's nuts.
Well, thank you very much, sir. I do note that we're at time, so to keep with our normal protocol, we'll go ahead and do a stay behind if people are interested for a few minutes. I know there are a number of questions, sir, folks that are interested with sharing their information with you. So I'll go ahead and pass those to you after this call. And then I know there are a number of folks who are also interested in your slides. And I'm not sure, I didn't want to put you on the spot, so we can address that after we stop the meeting, sir. So with that, I want to thank you very, very sincerely from the United States Air Force Academy and the Law, Technology, and Warfare Research Cell here, sir, for you taking time to talk to us about these very, very important issues, sir.
I'm available. You're out saving the world. I'm in the Steve Hawking camp. It can break this way, it can break that way. And this audience is going to have a disproportionate role in determining which way we break. And if I can be of assistance to you to make sure we break the way we want to break, you do let me know and do reach out. Thank you all very much.
Thank you, sir. Have a great day.